In this video, we'll be covering real property for our highly tested topics guide for the MEE. So to get started, the first thing I always like to point out is frequency and how you can expect this subject, real property, to be tested on the MEE. So real property, as you know, is an MBE subject. So it's fair game on the MEE portion of your exam. And in fact, statistically, it shows up about once a year. Now, with that being said, real property as a whole is being tested a little bit less frequently on the MEE. So still, statistically speaking, we see it about once a year, but it's not tested as frequently as it was historically. The other thing to keep in mind about the subject of real property is that it's usually tested alone. It's not usually tested as a crossover subject. So to put this another way, if you think the question is testing real property, it's usually just testing real property principles. Now, that's not to say that they can't cross it over with something else. Of course they can, but usually it's not. Usually the question just tests real property. So now that you have a little bit of a better understanding about the frequency and what to expect when it comes to a real property question, let's talk about how you can maximize your chances of success. And that is by familiarizing yourself with these highly tested topics and issues. So the first thing I want to point out is all about real estate contracts and deeds. Specifically, let's chat about deeds for a moment. Remember, there are two types of deeds that are fair game on the bar exam. Those two types are quitclaim deeds and warranty deeds. So let's talk about a quitclaim deed first. Quitclaim deed is pretty dangerous. It's really not offering a lot of protection to your buyer at all. Essentially, what a quitclaim deed is saying, the seller is saying, whatever I have, I'm giving to you. So think about that for a second. If there's no problems with the title or with the piece of property in question, well, then there's not an issue for the buyer. But if the seller doesn't have title at all, then the seller's not conveying title to the buyer. So this is really risky. There are no added covenants or protections or promises that are passed between that seller and buyer with regards to a quitclaim deed. Now compare that to a warranty deed. And the name probably gives this away. Warranty deeds come with warranties, specifically 6 covenants or warranties or promises, whatever you want to call them. And it's very helpful if you can classify these warranties as either present or future. And this is because depending upon the warranty or the promise in question and its classification as being a present or a future warranty or covenant will dictate who can sue who. So your present warranties or covenants, again, whatever you want to call them, is the right to convey, season, and no encumbrances. So when I call these present covenants, this means that they run specifically just between that seller and the buyer. So if they're breached, they'll be breached in that moment in time when title is being passed from that seller to buyer. So future buyers that come later will not be able to sue that original seller on these warranties or promises. These do not run with the land. Now, your future covenants or warranties or promises are a little bit different. These 3 are the promises of further assurances, quiet enjoyment, and warranty. And these covenants do run with the land. So when the seller sells a piece of property with a warranty deed and sells it to buyer number 1, if buyer number 1 sells the land to buyer number 2 later in the future, buyer number 2 could sue the original seller because, again, these promises or covenants run with the land. So it's helpful to be able to classify these warranties and covenants so that you can determine who can successfully sue who. Now, the other thing they like to test on the MEE exam outside of deeds is all about the execution of our contract of sale for a piece of real property. And specifically, they like to test the doctrine of equitable conversion. So what is this all about? Well, the doctrine of equitable conversion states that as soon as that contract of sale is signed, but prior to closing, the buyer's interest is in the real property and the seller's interest is in the personal property or the money that's going to flow from this contract. To put this another way, there are 2 types of title that emerge pursuant to this doctrine. There's legal title and equitable title. Legal title is going to stay with your seller until the day of closing when title officially passes, but equitable title now emerges and it is with the buyer. This is really important to understand as it relates to risk of loss. So once the parties have signed their contract of sale, if something happens to the land, maybe, a natural disaster or a tornado runs through the area, the risk of loss is going to be on that buyer, not on the seller. And that's because the buyer has equitable title. So understanding that and being able to articulate that is very, very important. Now, the next highly tested topic is recording acts. So first things first, I want to give you a little tip. And this is something that so many examinees skip over, and they're honestly just giving up pretty easy points. And we want all the points we can get, right? So the tip I have for you here, if you see your essay question testing recording acts, always start your analysis by discussing the common law rule. The common law rule is first in time, first in right. It's that straightforward. So to give you a quick example about what this means, if O gives to A, and then O gives that same piece of property to B, if you're analyzing who owns this piece of property under common law, first in time, first in right. So since O gave the land to A first, A would own the property. So always start there. Then move your analysis on to discuss whatever the recording act is in question. And what we find usually for our MEE fact patterns is that they don't explicitly tell you the recording act jurisdiction that you're in, but they tell you what it says. And it's your job to read the quoted language and interpret it. Usually they're testing a notice act, but they could be testing a race notice act, or they could be testing a pure race act, which are pretty rare. But it's fair game. So let's briefly walk through who each of these types of acts protects. So a notice act protects a subsequent bona fide purchaser for value who takes without notice of an earlier transaction. Now, a race notice act is everything that notice act is plus one other additional requirement. They must record first. So a race notice act protects those subsequent bona fide purchasers for value who take without notice of an earlier transaction and are the first to record. And then a pure race act, as I already mentioned, they're pretty rare. They usually reward the person who records first. Notice is inapplicable. Now, as I mentioned, usually they're testing notice acts, and normally they're testing notice. Remember that notice can come in 3 different forms. You do not need all forms of notice, you just need one. Our mnemonic here is AIR, A-I-R. That stands for actual notice, inquiry notice, and record notice. Do yourself a favor and get some of those easy points. Make sure you define notice for the greater and you spend time discussing it. It's not something that you want to gloss over because, again, usually your outcome will turn on notice. So you want to make sure you fully discuss it and flesh it out. Now, the next highly tested topic is all about mortgage liability. It wouldn't surprise us if they tested this more frequently. They already test it quite a bit, hence why it's highly tested. So first things first, you need to have a good feel for who that mortgagor and mortgagee is so that you can first interpret these vocab words and your facts correctly and use their terminology in discussing the facts. So the mortgagor is the homeowner. The mortgagee, double E, is the bank or the lending institution. So generally what will happen for bar purposes, though it's not really that common in real life, it's common on the bar exam. Someone will have a mortgage on their land, so the mortgagor, and they want to transfer their interest. And oftentimes the question is, who is responsible on that mortgage? Well, remember, the mortgage stays on the land, and determining who is responsible for that mortgage will depend upon if the land was transferred subject to or assuming. So, if the fact pattern tells you that the transferee is taking subject to the mortgage, this means they are not personally liable on the mortgage at all. So if the original mortgagor doesn't pay the mortgage, Well, it's not going to harm the transferee's credit because they're not personally responsible, but the bank can foreclose on their interest and ultimately kick that transferee out. And in most jurisdictions, if that transferee who takes subject to decides to pay the mortgage to avoid foreclosure, that does not mean that they've assumed the mortgage. Now, compare the subject to rule to assumes. When the transferee assumes the mortgage, they are assuming responsibility. So they are now personally liable on that mortgage. But don't forget that the transferor or the original mortgagor is liable as well. So now the bank, that lending institution, can go after either party. Now, the last highly tested topic I want to discuss are leases. They like to test landlord, tenant, and lease things more frequently than not. So you need to be familiar with the difference between assignments and subletting. If someone assigns their interest in their lease, this means they're giving everything that they have away. There's nothing left for them to come back to. Now, if someone subleases their interest away, there is something left on the lease for them to come back to. So I always urge people to look at who has it at the end, and that can help you determine if it's an assignment or if it's a sublease. The other thing they like to test in the Department of Leases on the MEE exam is they want to know if you know the duties of the landlord and your tenant. So the one that I want to discuss is the duty to pay rent. Tenants have to pay rent. So if they decide to move out and stop paying their rent in accordance with their lease, see if it's a surrender. Usually it is. They usually tell the landlord, here are the keys. I don't want to pay the rent here anymore. I don't want to live here anymore. So, pursuant to common law rules, the landlord did not have a duty to mitigate damages. They could just sue that tenant for the rent that was due. Most jurisdictions have modified that common law rule, and they will require that landlord to make a good faith effort in trying to get a new tenant in there to mitigate their damages. So now that we've covered some highly tested topics, I want to give you just 2 quick tips to help you improve your MEE real property score and or just simply prepare. The first tip is all about vocab. Understanding key vocabulary here in this subject is going to be key to you excelling. Because if they use some of these terms in your fact pattern, they're going to assume that you know what they mean. So you'll have to be able to interpret them accordingly. Additionally, it's nice if you can use these key vocab terms in your answer as well. This way, it looks like you understand the subject. You bring positive attention to your answer, and it really communicates to the grader you know what you're doing. So once you've memorized some of these key vocab terms, make sure you start using them and bold them or italicize them or underline them in your answer to draw that positive attention to them. So I'm not going to touch on all of them, but just a few. We've in fact already discussed a handful of these, like equitable conversion, the different types of deeds, warranty and quit claims, mortgagor, mortgagee, assignment, subleasing. Also familiarize yourself with easements, the tenancies, and adverse possession. So again, those are just a few of the key vocab terms you want to be familiar with. And then my final tip is practice. Be sure you're not only memorizing the law, but you're practicing the application of it. So you want to practice some essay questions. So that's it for our real property, highly tested topics MEE guide.